Constructive dismissal occurs when an employer makes an employee's continued employment impossible, unreasonable, or unlikely, or has made an employee's working conditions or environment harsh, hostile, and unfavorable, such that the employee feels obliged to resign from his or her employment. Common examples are when the employee is demoted, or when his or her pay or benefits are reduced. However, constructive dismissal is not limited to these instances. The gauge to determine whether there is constructive dismissal is whether a reasonable person would feel constrained to resign from his or her employment because of the circumstances, conditions, and environment created by the employer for the employee. Constructive dismissal does not always involve forthright dismissal or diminution in rank, compensation, benefit, and privileges. There may be constructive dismissal if an act of clear discrimination, insensibility, or disdain by an employer becomes so unbearable on the part of the employee that it could foreclose any choice by him except to forego his continued employment. Constructive dismissal has been defined as cessation of work because continued employment is rendered impossible, unreasonable, or unlikely, as an offer involving a demotion in rank or a diminution in pay and other benefits. Constructive dismissal has been described as tantamount to involuntarily sick resignation due to the harsh, hostile, and unfavorable conditions set by the employer. In the same case, it was noted that the gauge for constructive dismissal is whether a reasonable person in the employee's position would feel compelled to give up his employment under the prevailing circumstances. Insensibility to respondent's sexual harassment case is a ground for constructive dismissal. In this instance, it cannot be denied that respondent was compelled to leave her employment because of the hostile and offensive work environment created and reinforced by Batokan and petitioner. She was thus clearly constructively dismissed.